All right, let's get started. Hi, everyone. Welcome to our last program of the day. I hope you have been inspired and enjoyed our program. I'm going to be moderating this. I'm Sarretta McDonough, for those of you who have not heard me this morning, heard me at lunch and before, or didn't get me to attack you in the lobby to make sure that you're getting involved in NAWL. I am the president of NAWL. I'm an associate general counsel at Intel Corporation. I am moderating this panel, but before I do so, it is my great honor to introduce you to one of my favorite women lawyers, someone I call friend, someone who I not only admire, but who stands as the ultimate role model for me and countless others. Selma Moidel Smith became a lawyer and a NAWL member on the same day in 1943, over 75 years ago. I first met Selma at a NAWL mid-year planning committee dinner. I was lucky enough to be sitting next to her, and I remember her speaking in fluent Spanish to the waiter, and I thought, who is this woman? And I have got to get to know her. And I can tell you that it's been a wonderful journey of friendship since then. She is many things. She is a practicing lawyer, a writer, an editor, an activist, a published composer, and a musician. And she's a tireless defender of women's rights, like when she lobbied the California state legislature in support of the Wives' Paycheck Bill, which gave married women the right to collect their own paychecks. Yes, there was a time when married women couldn't even collect their own paychecks. We have come a long way. And Selma never sat on the sidelines. She was in the thick of the fight the entire way. I really can't imagine a world, and I don't think I want to be in a world without Selma Moidel Smith. So I am not going to try to summarize her multitude of achievements because there's just too many. We'd be here all day and all night. I ask you all instead to pull up her bio in your program materials. It's the longest one in there, by the way. And better yet, go listen to her oral history that you can find in the Library of Congress. Selma is one of the 107 women lawyers selected nationwide for the ABA's Women Trailblazers in the Law Oral History Project. And perhaps the fellows of the American Bar Association summed it up best when they bestowed upon her their inaugural Life Fellow Achievement Award in 2016 for a lifetime of extraordinary leadership, not only within the legal profession, but throughout the larger community and beyond. So she is simply quite extraordinary. Extraordinary in her abilities, her focus, her work, her dedication, her generosity, and in her gifts. Working with Selma does not feel so much like work, probably because she does most of it and lets others share in the credit. So while we are thrilled to have Chief Justice Cantil-Sakauye and Justices Corrigan and Werdegar here with us today, we are equally in awe and celebrate having Selma here with us as well. And with that, I'm going to cue the music, Selma's music, that is. For Selma's oral history for the ABA, Justice Werdegar was her interviewer and beautifully weaved Selma's music into that interview. We are taking the liberty and applying the fair use doctrine here today to replay a few choice pieces for you now while Selma takes over the mic for me. Please listen and enjoy.
I would like to offer something special at this time, a brief recording of Selma playing her own piano compositions from a group that she performed for the Women Lawyers Association of Los Angeles at their annual Law Day luncheon in the International Ballroom of the Beverly Hilton Hotel on May 1st, 1966. And yes, they are registered for copyright, like the rest of Selma's nearly 100 piano pieces.
law. I sometimes give vent to the mood that I'm in. And there you have it.
So Selma, you want to introduce the justices? Do you want to go with the introduction of the justices? Yeah.
As you see, I am a very dignified member of the profession. And now, when Chief Justice Cantil-Sakauye was sworn into office on January 3rd, 2011, as the 28th Chief Justice of California, she became the first Filipina American and the second woman to serve as the state's Chief Justice. I'm not sure that she even knows the impact that she made and the affection which she was received by our colleagues. And I can tell you, very quickly, everyone was talking about Chief Tani, our Chief Tani. That was how she was referred to. And she may like to know that in Southern California, I can say at least everyone knew just Chief Tani. She already had touched our hearts. And we are so proud to have her and wish, as I do, that she has an unlimited scope ahead of her and many years of success, because it's for all. And that was how she meant it to be, for all. In her 8 years in office, Chief Justice has emerged as one of the country's leading advocates for equal access to justice, transparency, and reform of state court funding models that unfairly impact the poor. She has called for bail system reform while addressing concerns about fairness and public safety. She has asked federal authorities to protect the integrity of the state court system by not arresting undocumented residents at state courthouses. As the leader of California's judicial branch, she has led efforts to address how the judicial branch can prevent harassment, discrimination, or inappropriate workplace conduct. She has convened leaders to address issues of implicit bias, human trafficking, and truancy to keep kids in school and out of the criminal justice system. She has led efforts to revitalize civic learning and to inform the public about how the courts, both federal and state, play a key role in state government and our constitutional democracy. I will proceed next to Justice Corrigan. Justice Carol Corrigan, and I shall just say Carol after this because she's a jolly good fellow, was appointed Associate Justice of the California Supreme Court on January 4, 2006, having previously sat as an Associate Justice on the Court of Appeal and a judge of the Alameda County Superior Court and of the Oakland Municipal Court. She has been an adjunct professor of law at the University of California, Berkeley, Boalt School of Law, the University of California, Hastings College of Law, University of San Francisco School of Law, and the University of Puget Sound School of Law. You wonder why she just never could get her lessons in right. She is currently an adjunct professor of trial advocacy at the University of Notre Dame. In addition to her opinions on the court, she's published in the areas of criminal law, trial advocacy, ethics, evidence, and constitutional law. In 1970, graduate of Holy Names College, Justice Corrigan studied for a doctorate in clinical psychology before taking her law degree from... You took it from them? You didn't just get it? You had to take...
They weren't just handing them out, you know.
Well, she took it, we know that. And from the University of California, Hastings College of Law, where she was a note and comment editor for the Law Review. She serves on the Board of Trustees at Holy Names University and is chair of the Board of Directors for St. Vincent's Day Home. She has also served on the boards of Goodwill Industries of the East Bay and Providence Hospital. She is wondering what she might do tomorrow or so. You know, it gets boring when you're not doing anything. And now to Justice Catherine Werdegar, who is now retired. Catherine served on the California Supreme Court for 23 years. If you can envision, well, let's not. She was the third woman ever appointed to the court. Before her appointment, she served on the First District Court of Appeal in San Francisco, where she was the only woman among its 19 justices. Justice Werdegar is known for influential decisions in the fields of environmental, employment, and criminal law, and has authored groundbreaking decisions advancing the parental and civil rights of gays and lesbians. With regard to the environmental, this is something that is a part of her life. I know because I know her a little better, and I know that she takes hikes every week. She lives the whole doctrine. It is not that she simply talks about environment and the redwoods and nature. And this is something dear to her heart. And she spreads out her goodwill on all the nature's presents to us. And I must say, she is a wonderful ambassador back to our Creator. Justice Werdegar also holds law degrees from both George Washington University School of Law and the UC Berkeley School of Law, managing barely to squeak through as the first in her class in each school. First in her class. She was the first woman to be appointed editor-in-chief of the California Law Review. Earlier in her career, Justice Werdegar served in the Civil Rights Division of the Kennedy Department of Justice as a professor at the University of San Francisco School of Law and a staff attorney on the California Supreme Court. She enjoys studying piano. Ha ha ha. Where she has a full copy of book of my compositions. And complains to me that she doesn't have the innate Latin rhythm, and she's working hard. But I'm sure all will come out well. And she is looking forward to mastering, as she said, some of my Latin tangos. So you know what you may expect of her in her retirement at any time. You just never know. We may have a duet of some kind. Yes, of course. All right. Now, the only thing left that I have to do at this moment is to let you know I'm going to read you a little note. Gary Green and his Los Angeles Choirs Philharmonic will perform music of Selma's and celebrate her 100th birthday at their 10th anniversary concert at Walt Disney Concert Hall in Los Angeles on Saturday evening, June 29, 2019. That's so that you go, so that you can all drop everything else you're doing back there. And, we'll have the tickets out to you by morning. But that's something I'm sure you'd want to know. And by that time, let us just say, enjoy my music. Very well. I shall now reluctantly yield. And let's see. Yes, and now we will let us have a few words. I mean, I hope they'll be mindful of time. You know? Chief Tammy, would you like to come forward?
Of course.
Yes. You may discuss now the journey getting into the profession and discussing the journey getting on to the bench.
Thank you, Selma. Thank you for that very kind introduction and your beautiful gift of music to all of us. Thank you.
So I've got, I'm going to do like inside the actor studio. I chose blue just for those of you who've seen that show. So that's my my cue cards. Thank you so much, Selma, for everything. So I think, you know, obviously we're just so thrilled to have Selma and the Supremes here today. And the first question we have, I think everyone's always interested in, is sort of the path and journey into law and the path and journey onto the bench. And so we're going to start with the Chief Justice. And if you could sort of just kind of explain sort of your journey, I think everybody here would love to hear.
Thank you. And I want to express my gratitude for NAWL offering this invitation and sitting with some of my most favorite people in the world. And of course, when Selma calls, you answer. Selma is probably the only name at the Supreme Court where everyone knows first and foremost by first name. And all of our assistants know to contact us immediately when Selma calls. So Selma, thank you for the invite as well. I think my journey is like many of yours in the sense that I grew up witnessing family issues that I didn't understand. Why government was having us move out of our home, how could government order and take our home, how it is that my Filipino uncle had to go out of state to marry his French wife, why my grandmother was afraid to put property in her name, and there was a huge quarrel in the family about how and why the name of who should own and possess this property should be not in ours. And so watching this and learning and knowing the true excitement that my family felt and ever witnessing and seeing the first Filipina woman in the flesh, where the entire Filipino community came out to see her, me at whatever age not knowing what that was, and my mother saying, you can do that. And my mother was not a woman easily impressed. Really impressed on my mind that whatever being a lawyer meant or was something really important. And then as I went through school, I was encouraged by others to consider law, and I knew of people who were entering law, and that's when I started to study it. And so my journey was really one of, thankfully, people encouraging me, and me not knowing enough to know whether I should or shouldn't try, but why not? And also then getting to the bench was really a matter of simply showing up every day, doing the best I could, finding out opportunities, networking with others to find out what was available, and always putting myself out there, rejection or otherwise, for the experience of being able to try for the position. And for all the jobs that I had, I can say that every single job you have prepares you for the bench, because you take the best of all jobs, and mind you, they're not all great, especially when you start out and you're female and or minority, and you take the best that you can and you build your own portfolio of skills and talents, and you keep the company of good people and you learn from good people, and actually you apply. You put yourself out there. And I was lucky to actually work for governors who made it possible for me to come to the bench, and then thereafter build upon the application process to get to the bench. But none of it was planned, actually. A lot of it was throw it up in the air and see what comes back, and working with good people.
Thank you. Justice Rudiger, would you like to share your journey with us?
First, I'd like to say we are so fortunate that our chief's mother said to her, "You can do that," because we now have her as Chief Justice of the state of California, and it's been such a pleasure when I was serving with her. Some of my career path echoes hers in the sense that it was never planned. I never knew what I was going to do. But I go so far back in time. Selma goes a little bit farther back. But so when I graduated from Berkeley, this is an era thing. Most of my friends got married right after graduation, and some of them went to teach primary school. I had been a liberal arts major. I went over to the University of California Hospital in San Francisco and applied for a job, and I became a ward secretary. That's where you make up the patient's charts and you take them off to x-rays and you answer the phone and you make everybody happy in the doctor-nurse realm. Well, there I saw 2 women physicians. I go so far back that I'd never heard of a woman, anything, except a primary school teacher maybe, physician. And this really opened my eyes that there were perhaps other possibilities in my life. Now, as I've said before, you should all be grateful I didn't choose medicine. But I thought, well, this was sort of an arbitrary thing. Why not law? Law is a good education, which indeed it is. And I'll just go to law school. So I applied to Berkeley Law, and they took me. There were 4 women that started in our class and 2 that graduated. So this history is not going to be relatable to you. At that time in the United States, 1% of women were attorneys. Heaven knows how many women. Selma, because she may have been the only one. And in California, because we're always progressive, 3% of attorneys were women. So I graduated from law school, and my husband and I were living in Washington, D.C., and it was the Kennedy administration, which when you're a young person, that was a very exciting administration. I applied to the Department of Justice, Civil Rights Division, and if any of you have seen the movie Green Book, that was the era in which I applied to the Civil Rights Division. I came back to San Francisco, and it was a different story. I thought it would be wonderful to work for the State Department of Justice, and I applied, and nothing came of it. My law school, looking out for me perhaps, said that there was a law firm in San Francisco that was thinking of maybe taking its first woman if they could persuade the senior partner. So they took me to lunch, and I'll freely say I probably was not a great interview, but no offer was coming there either, and I didn't know where this degree was going to take me. Berkeley Law, still looking out for me, called and said that an entity known as the College of Trial Judges, it's now the Center for Judicial Education and Research. They wanted to write the first statewide bench book on criminal procedure. In this case, it was misdemeanors. So would I be willing to do that under their auspices? And I was. After I did that, I applied again in California to Continuing Legal Education of the Bar, CEB. And they took me on. They did have women. And we wrote books and we organized continuing education programs. Then the dean of University of San Francisco Law School, who had known me from Berkeley Law, called me up and asked if I wanted to interview to be associate dean of the law school, and I did. And when he went out and the new dean came in, it was quite clear that I wasn't going to be kept on. I didn't have tenure. And I applied to be a law clerk, and I ended up being a law clerk on the California Supreme Court. Now, when I got out of law school, this was not a career path, but now in California, it had become a career path. Well, fast forward, 20 years had passed. Times had changed. People were looking for women. They wanted, entities wanted to have their woman, you know, their one woman or two. And some of the judges that I knew encouraged me to apply for a judgeship. And I did have to be pushed. Some of us don't have all that much confidence in what we can do, and I had to, but I did. So I was prepared at a time when the world had changed. Now, my good fortune was that I was prepared, and my good fortune was that the world had changed. But interestingly, in my case, the good fortune also was that the governor knew me. He had been a classmate of mine at Berkeley Law. And ultimately, he did appoint me to the Court of Appeal. I was his first appointment in the state. And later, he elevated me to the Supreme Court. So it's a path that's not likely to be replicated. But like the chief said, I couldn't have anticipated any of it. And you just do what you do and do the best you can do and see what life affords you. So that's my story.
Thank you.
This is Corbin.
All right, so I was the first in my family to go to college, and I graduated in 1970. Now, I'm not nearly as accomplished as some of the other people on the panel, but for most people like me, who graduated from college in 1970 as a woman, you could be a teacher, a nurse, a secretary, or a social worker, all of which are perfectly wonderful professions, but it's kind of a narrow band. And medicine was out, which was great for the medical profession in untold numbers of patients. So now I was down to 3. And so I decided to go to graduate school and study for a doctorate in clinical psychology, which my parents were convinced was like voodoo. But they were supportive of my education. And while I was at grad school, I met several women who were in the law school, which was a concept completely foreign to me. And I began to think, well, you know, if they can do this, maybe I can do this. So I remember calling my parents one day and saying, what would you think if I came back from St. Louis and went to law school? And my mother said, terrific. Now I have to tell you that if I had said to my mother, what would you think if I came back to California and became a pole dancer, she probably would have said, terrific. But that happened, and I went to Hastings, and I was lucky enough to get a job as a prosecutor in Alameda County. And I loved being a trial lawyer. It was, hands down, the best job I ever had, including the one I have now. I'm sorry I have to say that out loud. And so there I was, trying cases in Oakland, and really very much enjoying it, and being kind of amazed that they were actually allowing me to do it and paying me. And a woman who had been in our office had gone on the bench, and she would call me periodically and say, you know, you want to think about putting your name in for a judgeship. And I would laugh, and then we would both laugh, and then I would say, come on, people like me don't become judges. And she would say, no, you really ought to think about this. And she was very persistent, blessedly for me, and after, I don't know, quite some time of her calling about every 6 weeks to say, have you filled out that application yet? I finally thought, well, okay, here it is. I have a job I love. I'm not bad at it. I'm never going to get this, but it's not going to cost me anything to apply. So, and if I don't get it, I'm stuck with a job I love. How bad could that be? And I was very blessed that Governor Deukmejian was willing to appoint me to the municipal court, which means that I'm so old that I have a job that doesn't exist anymore. And then I was able to do a number of things, teaching and so on, and then I kept getting run out of jobs, and was ultimately I think Governor Schwarzenegger was having a bad day, and I think maybe he signed the wrong form, but it worked out okay for me. So I have been blessed to work with wonderful colleagues, and I think the lesson you can draw from really all these stories is listen to people who can look over the horizon for you. you may not always think that, you know, if you have a mother who's saying, you can do this, that's great. We all have people in our lives who, amazingly to us, can say, you can do this. Listen to those people, because they're urging you to do something that you may not feel always completely ready to do. But if you're willing to take a risk now and then, really very cool things can happen.
You know, I really, really want to endorse that. I really do.
She so seldom endorses anything.
I concur. If you're fortunate, there's somebody in your life who sees something in you that you're not ready to see, and that's so valuable. And I want to echo something else that Justice Corrigan said. The vision. You saw women attorneys. You thought maybe that would be interesting. Your mother took you to hear a woman attorney speak. In my time, nobody I knew had ever heard of a woman attorney, but I saw those women doctors. So role models are so important, and many of you out here perhaps have had role models. I'm sure, I hope most of you will be or are role models to other people. I've said before, if you can't imagine it, you can't do it.
And I think it's really amazing that it was women at each turn in your journeys that was the difference. And I don't know if many of you should go back to the Women's Law Journal from last year. Selma has an interview in there, and her mother too was that important woman in her life that put her on a journey to being a lawyer. She had no choice. Her mom wanted to be a lawyer. Her mom didn't have the opportunity to be a lawyer, but all 5 children became lawyers. So she got hers in the end. But I think it's interesting, right, that we're here, and it's not a man who was a lawyer who said, you should try this. It was these women that you saw, whether they were doctors, and all of a sudden he said, oh, wait, why am I looking at the world so narrowly? And my mom, and that wanting to, sort of similar to Selma, wanting to sort of live up to what the expectations may have been, that maybe you might not have raised yourself up to, but others saw, just like with you, Justice Corrigan. So I think that's really interesting. Chief Justice, I know, we are all women lawyers. So many of us are also diverse women lawyers. Did you find the diversity prong of your experience to create more hurdles or more issues in addition to the gender issues that you faced?
Thank you. I definitely did, only because in my first job as a prosecutor, there was one other Asian woman in the office, and they all thought we were the same person. And that was cool for me because she was good. And so I didn't correct them if they thought I was Cheryl. And the same was true for the judges, who also couldn't, for some reason, tell us apart, even though we couldn't possibly be in 2 places at one time. And I noticed, we didn't know what it was. I know Carol and Kay can talk about it, but I didn't know what the awkwardness was. I was a prosecutor. I just knew when I walked into chambers, we didn't call it gender bias. I didn't know what it was, but the men attorneys were just weird and uncomfortable around me. And they didn't know what to talk to me about. So we'd sit at table like, and then I noticed when we'd go in chambers with the judge, it'd be, hey, how about golf? How was that boating trip? Did you go to that event? And I'd be there like this, waiting. I have nothing in common. I don't join these clubs. I don't play golf. I don't know your wife. This is how it works. I'm a single working prosecutor. And sometimes the judges would come in and say, okay, hon, what's the problem? Or a lot of, sugar, what's your objection now? But again, I wasn't going to change their minds, and I wanted the win on the ruling, so it's not as if I objected to that. I used it to my advantage. And I would talk to the judge about what I needed and get it, even though there was sugar and hun on both ends, because eventually those judges retire and we move on to a different generation. I would say too that being a diverse woman also meant that on top of all of the other mistaken beliefs that you are the clerk or you are the messenger, that they also think other things, because the implicit bias, the unconscious bias, especially when I was a prosecutor in the 80s, was we don't see you. First of all, we don't see a lot of women in the courtroom. Second, we don't see a lot of ethnic women. And we certainly don't see women acting up, and we don't see women getting in the faces of defendants on the stand during cross-examination. And a jury of 12 who expects you to be also of the community. They see you. They look at me, I'm a small Asian woman, and they think she's going to be polite, she's going to be quiet. And I'm in the face of the defendant, and I am pointing my finger and shaking it at him. And we are having an interlude, and people are like this. And so I think early on in my career, they had a nickname for me, which I really didn't understand, but I later looked it up. And so they used to call me the bantam rooster. And they said, I was bantamweight, so I really, that's a male thing. I had no idea that meant to wait. And I think rooster because I was no holds barred if I found a lie or thought I was in the middle of a cross-examination. And so it's a competitive world in a trial court, but in a trial court you have not only the male defense attorney and often the male judge in those days, you had a jury that just wasn't used to seeing women in a courtroom being assertive and trying their case. And so it just meant really a lot of humor, a lot of understanding, and the camaraderie of other women in similar circumstance, so that when you went to bar associations at the end of the night, you could laugh about it with someone who was also having the same experience, so you didn't feel alone in the process.
It's funny that you say sugar and hun, and the fact that we all have an audience that we speak to, whether it's a judge or a jury. One of the things that NAWL does is we try to provide real-world skill sets and training for women lawyers. But we don't try to pretend that we live in a fantasy land and that the world will adjust to us and get used to us. We actually try to give them real advice and skills to work through what they're going to face in the real world, knowing that over time, hopefully, those judges will retire and life will change and that the world will start to adjust to the fact that we're here and we're not going away. So I wanted to ask you all for advice to our lawyers, because part of what we do is give them advice. When they're appearing in front of your court, when they're appearing in front of a judge or a jury, what advice do you want to extend to our members on how to be the best advocates for their clients? And I'll start with Justice Werdegar.
I'll leave it to my colleagues to speak to the trial court because I didn't sit in the trial court. On the appellate court, and I'll speak specifically to the Supreme Court, where how many of you know how many justices we have? We have 7. The United States Supreme Court has 9. So there's 7 of us on the bench. You will, of course, arrive in court well prepared. You have your argument nailed. What's going to happen? You're going to be interrupted. So my first advice is understand that that's what it's about. It's a conversation. You will be interrupted. And what you won't do, as a former justice of our court did when he appeared as an advocate later, what you won't do is say, I'll get to that later. No. You'll say, yes. You'll say, yes. Thank you for that question. Yes. And from there, you may be able to pick up the thread of your argument, or you may not. It could be a free-for-all. And sometimes you'll wonder, where is that question coming from? Or you'll say, I just answered that. You have to deal with it impassively. So be prepared to be interrupted. You've probably heard the adage that there are 3 arguments that an attorney gives. The one you prepare, the one you give, and the one you wish you'd given. And that's how it goes. Always be honest with the court. If facts are bad or the case is against you, don't try to disavow it or fudge it or so on. Deal with it. Be prepared to deal with it and explain if it's a bad case, explain why it is a bad case and why perhaps the law should be changed, but deal with it. So your credibility is the coin of your reputation in your realm. Of course, you're going to be completely familiar with the record and the cases. You're going to know. Sometimes you're called in as an appellate advocate. You didn't try the case. In fact, most often before us, the attorneys have not been the trial attorney. That's developed since my early times, when appellate practice is a special skill. Once in a rare while, we'll have an attorney appear before us and we'll get off the bench and say, he's a trial attorney. Because he thinks we're the jury and we're not the jury. So be honest, be prepared to be interrupted. If you can't answer a question, and that does happen about law or something, apologize and move on. Say, if the court wishes, I'll submit a supplemental letter. I probably needn't tell you to dress conservatively. You do not want to be a distraction to the people on the bench. You want them to be hearing about your case and your client. So those are my bits of advice.
Thank you, Justice Corrigan.
So I was not called the Bantam Rooster, because Bantam was never going to be. I was called the Barracuda. But I remember as a young deputy, and there were only a couple of women in an office of 140, they had a training program for us, and they brought in all the really first-rate trial tigers. And there was one fellow, I'll never forget it, he goes, okay, here's the deal. When you're in the courtroom, you are in charge. The judge thinks he's in charge, and it was always a he. But you are the show. You have to take control. You have to dominate every witness. You have to do this. And I remember thinking, okay, I came from a little Catholic women's college. I'm not sure that's going to work very well for me. Because if I try to be that guy, I'm going to be something very unpleasant and something that I don't want to be. So everybody has to find their own voice and their own style. I had a colleague in the office who was about 5'2", and she became known as the Velvet Hammer. She would do, and she's the most soft-spoken, decorous, charming woman, and she would cross-examine someone, and then they'd get up from the witness stand and all their limbs would fall off. Because she had done such a fabulous cross-examination, but it was never harsh. I was more like waving my finger at them. And
I'm surprised.
Saying, I know. But you must find a style with which you are comfortable first. If you can't develop a style that works for you and live in your own skin, everybody's going to know that. Everybody's going to be uncomfortable while they watch you work, and it's just not going to be a good thing. Don't think that you have to adopt a style of the guy who said, you have to be the biggest, baddest person in the courtroom. Don't think that there's one size that fits all. Remember your audience, and remember to connect with your audience. For the most part, people want to see other people do well. It's not fun to spend 2 weeks in a trial and watch somebody not do well. So assume that your audience is wishing you well until they prove otherwise, which does on occasion happen. Make sure not only that you are not a distraction in the way you present yourself, but do make sure you can be heard. You can be heard in a lot of different ways, but you must make sure you can be heard, otherwise the argument either you planned or you give or you wish you'd given will make no difference because no one will get it. But do feel empowered to adopt a style that works well for you and in which you can be comfortable doing your professional work.
You know, one of the things you said in this whole genuine, being authentic and being genuine, you know, it sort of echoes our first panel of the day. And it was one of my favorite quotes that I wrote down in my book when I was listening. And it said, and the person said, you're only your second best when you're trying to be somebody else. To be really your best, you have to be true to who you are. And I remember early on in my career, you know, there was one lawyer who I just thought, oh, he's just so spectacular. And I just really would love to be like that. That's what I'm going to be like. And I struggled with it. And I remember we had a practice jury session with these people from off the street who were our jury, and we're associates, and we do a whole little jury case. It was great. And I remember we asked the jurors for advice afterwards. And the advice they were giving was exactly that. They said, you know, as soon as you kind of got off the formality and just kind of started to be a normal person, we really, that resonated. You became much more believable. And I think that's the gift, is that everybody has different gifts that they're given. And wouldn't it be nice if we could pick the ones that we like the most? But we gotta work with what we got. So thank you, Justice Carter, and I agree with that. So Chief Justice, how about you?
Well, I wholly endorse all that's been said. I have something to add only in the sense that I know at the appellate level, and some of you are appellate practitioners, you have to know when you're coming before a court of review, you not only need to be prepared and know your facts and not be distracting and answer the question, but you have to have a rule in mind. You have to tell us what you want and why. And mind you, you have one case in front of us. We're hearing 6 a day. So first of all, stand up and tell us who you are and who you represent. We know it's abundantly clear. I'll figure it out by the middle of your argument. I know petitioner respondent, but why don't you make it easy? Tell us who you are first. Tell us who you represent. Tell us what you want to do. Affirm the CA. Reverse the trial court. Be clear. Communicate at your best, because we're 7 ready to have a conversation with the best expert in the room, you. We have so much in our heads, and we want to talk to you. And we want to ask you about the rule and why, and so being able to support it. And almost always expect a really weird hypothetical, because now we need to test that rule. And so you need to persuade us, and we're open to persuasion. Just we do need to explain it. The only thing too I would say about trial court practice, I was a trial judge for 14 years like Carol, and I would say this. In a trial court, you have to make sure that you are guarding your record. You must make your record. You must finish your thought. You must finish your motion. You must get that ruling. If the judge defers it, you have to get it. You have to explain why or why not. You need to explain physical movement. The witness is making physical movement. We don't know what it is unless you describe it. So really, you are writing and editing and illustrating the book that we at the Court of Review will read. And if it ain't in the book, it didn't happen. You know, some of us can surmise something happened because this is an odd arisal from what we're looking at when we're looking at a record. But you are the captain of that record, and you must make it, and you must make it in complete sentences, and you must try to be as accurate as you can be. And if you need to go back 2 days later and say, you know, by the way, I was talking about juror number 153. I know I said juror number 133, but I want to correct that now, so that on review, we know what you're talking about. It's so important that we know what it is you were trying to convey for us to be able to do our best job in reviewing the case for you and your client.
That's great advice. I remember when I was in trial as an associate, and every day after trial, we would get essentially the rough transcript, and the partner and we would go through the whole thing that night. And because you think you've heard something, and you think, it's clean, it's clear, we don't have to worry about that element anymore, we've got our evidence, we can move forward. And almost every time you go through that transcript and you go, well, maybe not exactly, or the transcript is wrong, there's an error. And it happens, we're all human, right? And the time to find that error is that night, and the next day you can come in and the clerk or whoever was doing it and correct it, versus when you're down the road and you've hired your appellate lawyers and they're like, well, I thought this doesn't make sense. And you go, oh, well, wait, no, he actually said this.
Yeah, you had to be there.
Yeah, you had to be right. Exactly.
And looks to us like, So you need a yes or a no?
Yeah.
Is that a yes?
Yes, exactly.
So when you're arguing to anybody, remember that part of your job as an advocate is to make their job easy. You know, make it clear what you want the court to do, just as the chief said. And the most amazing thing, remember that if you're arguing at the Court of Appeal or you're arguing in front of the Supreme Court, and often when you're arguing in the trial court that's going to write a statement of decision, we have to take what all this excitement is that happens and write it down. And we have to write it down in a rule that is often brand new or a nuance on something that's happened before. And so we will say to an advocate, well, what's the rule that you would like us to write? You'd be astonished at the frequency with which people look at us like, wow, what a question.
I thought you would figure that out for me.
And then they will say, first they make a motion in their throat that looks like they're trying to swallow a typewriter. And that, you do remember what typewriters are. They're great big boxy. And then, because they clearly haven't thought about that, they will say, well, the rule ought to be, and they'll go on for like 4 paragraphs. And you think, well, no, that's going to be kind of not a very good rule. Or, no matter what they say, it translates to, my client ought to win, because we really need this one. So you have to remember that we're not going to write any of those things. We aren't going to write a 17-part, 4-paragraph test. We can't just say, okay, you win. We have to say why. So be prepared to make either your judge or your trier of facts job easy. Here's what you ought to decide, and here's why, and here's what it ought to look like.
Thank you. I'll go back to a small point. We've heard some very large points, and I've really enjoyed what I heard. But you're standing in front of the 7-person court. And this was prompted by the chief's statement that when she was in the district attorney's office, there was another Asian woman, and they just couldn't tell one from the other. So when I joined the California Supreme Court, there was another woman, and that was Justice Joyce Kennard. Many of you perhaps know Joyce Kennard or remember her. So now there were 2 women on the bench. And we actually would have, once in a while, an attorney look right at me. I would have asked a question, and they'd say, Justice Kennard? And I did not correct them, but I was sort of dismayed by this. But I read that when Justice Ginsburg joined the United States Supreme Court, now picture Justice Ginsburg and Justice O'Connor, picture Justice Kennard and myself, that Justice Ginsburg would sometimes be addressed as Justice O'Connor. So it was very confusing that there were 2 women that, sort that out. But my advice to you to extract from this is you are nervous and so forth. All you have to do is say Your Honor if you're not sure. Just Your Honor. Yes, thank you.
Great, that's great advice. So I'm going to shift a little bit to some of bigger picture issues and get your thoughts. So from your vantage point, where you sit and where you sat, what are in your mind still the biggest challenges, either old or new, that you see for women in the judiciary and maybe in law generally? And Justice Corrigan, we'll start with you.
Well, I think anytime you are perceived as being anything other than what everybody's used to seeing all the time, whether it is your stature or your gender or your nationality or whatever it is, you have to remember that it is an unfortunate truth in life that often people think they like and trust people to the degree they perceive that they are just like them. That's not a particularly charming human trait, but we do have to acknowledge that sometimes that's true. And so if you are in front of an audience, whether it's 12 people in a box or it is a person of the old school who may not be quite as expansive in their thinking, you're going to have to deal with that. And one way to deal with it is to emphasize all the things that do make you just like them. Not necessarily to emphasize the 1 or 2 things that may set us apart, but to establish yourself as a well-prepared, intelligent, capable professional who can be trusted. We know that, going back to Greek rhetoric, it's ethos, pathos, logos, right? It's the emotion of the case, it's the logic of the case, and it is ethos, the reliability, the perceived reliability of the advocate. And so you are looking for ways to present yourself as a reliable advocate. And if you know that you may be pushing a sled uphill on gender, then okay, you can either go home or you can deal with that. And probably going home wouldn't be a good idea because you wouldn't get paid. So, you know, you have to figure out other ways, and then the gender thing will take care of itself. I had a judge when I was a young lawyer, and there was another woman in the district attorney's office who was 5'2". He could not keep the two of us straight, which is kind of not very understandable, but it was true. And one day after I had tried a case in his courtroom, and he was a wonderful man, but he was a gentleman of the old school. He was a decorated veteran from World War II, and he was who he was. So I said to him, "So, Judge, what do you think about the trial, and do you think I might have a future in this business and stuff?" And he said, "Absolutely." He said, "There's a woman in your office, I can't remember her name, now there were only like 4 of us, but she is so good. You ought to watch her every time she's in court. She is so good that when she's trying a case in your courtroom, you forget that she's a woman and you have to protect her." Okay, now, you know, now you're in the moment. That has been said to you. Probably punching the guy in the nose is going to be a counterproductive response, you know. But you have to take people where you find them and bring them along with you. And if my colleague got him to the point where he forgot she was a woman and he had to protect her, and he was just admiring her as an effective advocate, she was making headway. You make headway one person at a time, you make headway little steps at a time, but you have to keep making headway.
Chief Justice.
I would say to you, some of us choose to have families in the middle of our careers, and for some of us it's a timing. Like I went to law school, and so therefore I'm a little later than all my friends and relatives with children, and I'm working hard, and I really don't meet someone to have children with, and when I do, it's hurry up, the color is pink, come now, come home. And you know, because it's business at that point. Great amount of love, but it's business. And so you succeed at your greatest height. You know, now I have 2 children. And you have to make choices about your career. And I will say, the greatest thing in my life are those 2 girls that I have who are now in college. I wouldn't trade that for all the greatest, best possible jobs in the law ever. For me. And so you have to balance. And okay, I'm going to say with all true belief and respect, I don't know, is it 50-50? I don't think so. No, it's not 50-50. If it is, that would be news to me. Women will still be the laboring oar. Even if it's all the wonderful details that make memories for your children, you know, making the best goodie bags for the party, you know, making sure you make all of the arrangements down to the last detail, because you bring who you are to how you bring up your children and how you micromanage their lives. And that will take a huge chunk potentially out of your career. You can't just really be everywhere and all things. And so for me, I ended up taking assignments in the trial court. I was a judge by then, hence this business. And I had to take assignments that weren't as glamorous, that wasn't going to get me the kind of notoriety or get me noticed or get the big pressers. I took the jobs that I could work around my schedule. I didn't pick jury trials because I had children I needed to get some places and get to the doctor, and so I couldn't leave a jury waiting.
It
so
seemed like that okay for you, though.
Yeah.
Yeah, well, I'm saying, that's it. That's the whole point. And the point is, your profession is long. So make sure you take time out for yourself and to build things that are also equally important. And I learned this very interesting piece, is that when I had to get everybody out of my courtroom by 5:30 because I needed to go pick up my kids, I would just yell it from the bench, "I'm leaving in half an hour! So get up here and have your case before me." And you know, the male attorneys wanted to get home too. They wanted to pick their kids up too. Or they wanted to do their percentage in there too. So I found out that they liked coming to my court because they knew I would be saying, we gotta go, get your business done. And it became kind of the rhythm and norm in criminal court in Sacramento to know that you get your case done if you went to Cantil's chamber, because she gets you out of there.
That's great, thank you. Justice Whittaker.
Chief, thank you for that. And now I know a lot more about you. But I relate to that. I have 2 sons and now grandchildren. In the beginning, I worked part-time. Well, as you have heard, in the beginning, I had no idea where I was going. So I do relate to that. And the challenge, which I was going to mention as well, is this business. It's still, many of you perhaps are married, many of you perhaps have children, and it's more understood now, but younger men are more liberated, as you might say, than men of my generation, where they didn't participate at all. Nevertheless, as the chief said, so often the burden of the schedule, the transportation, and the caregiving, whether it's a sick child or your parents, whatever it may be, falls on the woman. Now, if you've seen or know the story of Ruth Bader Ginsburg or seen one of the documentaries or movies, she's the woman who, many years ago, when the school called her, there was a problem with her daughter or something, and this child has 2 parents. She's famous for having said that. 2 parents. Now, again, if you know her story, you've seen the movie, not very many of us have a Marty Ginsburg for a partner. We don't. He was a saint in an era where it was just unusual, beautiful story. So that is a perennial problem, and there's no one answer. You have to kind of go with it, do the best you can. The other things I was going to mention, going back to the chief and her meetings in her office when she was one of the 2 women they couldn't distinguish. When I was on the Court of Appeal, I mean, I wouldn't have said this publicly, but you brought it up. My husband has been heard to say, to my great irritation, that on the mornings on the Court of Appeal, when we would conference with my division, he would say, Kay would read the sports page. Why? So she could be conversant with her colleagues. I mean, I was embarrassed when he would say that, but my chief has gone before me, and things today, I'm sure, are better. Please tell me they're better. Well, there's a critical mass of women. That is so different. In the beginning, what challenges are old? You were not respected. You didn't get the automatic respect that a male does. You had to prove yourself. And again, as the chief mentioned, and I think Justice Corrigan as well, some of the old guys have retired now. But when I came on the court way back, I don't think I was particularly welcome. That's just how it was. Their wives were not professional women and so on. Some of them had daughters that they aspired would follow that path, and they were a little more generous. I hope those challenges are over. And again, I hope this next challenge, that your voice is not heard. Again, on the Court of Appeal, at a meeting with 19 of us, I'm the only woman, I remember vividly saying something, it's classic, and no attention paid, and 2 voices later, a man says it, and they take it up. And again, I go back to Justice Ginsburg, who we know is formidable, and these things happen to her too. She's quoted as saying that. So that's how it was. I hope that's not how it is. The thing you have to do is, just as been referenced by my colleagues, you have to just charge forward. You just have to, be bold and have confidence, which I'm told women perhaps don't have as much innate confidence as men do. I don't know if that's an improper gender stereotype, but speaking personally, you just have to pull yourself up and charge forward.
Which I think is what we've been doing throughout history, and I think we'll continue to do, and it's just part of why we're all here today. One of the things that you do as justices on the court is build consensus and create relationships, because I was obviously part of the give and take and getting opinions done. How do you go about and doing it from your perspective, and how do you succeed in building relationships and consensus? And Judge Whittaker, I'll start with you.
It is important, and having relationships makes getting to consensus a lot easier. But building relationships takes time. It takes time. And you have to share something where you come to know one another. Either share the same point of view, so you're discussing a case, or share work on a committee where you get to know the quality of the other person, or go out to lunch and maybe our share of birthday, which Selma and I do pretty close. We celebrate it every year, and I'm looking forward to celebrating it in April every year. So you have to share something to build a connection. Maybe if you go out to lunch, you find that your kids are in the same school or having similar problems. Something to bring you together so you learn about each other and trust each other. It comes more easily to some than others. Some of us are shy and introverted. It's not so easy to reach out and to, it's not. You have to do it. If you have a problem, you can go ask a colleague what that colleague thinks, and they might then become sort of a patron or a champion of you. So that's how you build relationships. It takes time, but it is so valuable, not just for an end result in particular, but for just cherishing that relationship in your profession and in your life. So that's my advice. This is Morgan.
I think it is absolutely true, particularly if you work like we do in a group of 3 or a group of 7. Once that relationship begins to go sour, then it's really bad because you're stuck there for however long you're there. And so I think part of it is beginning with a commitment to collegiality, and with an expectation that you're going to try pretty hard to find middle ground until it becomes apparent that you just see it differently. So, just saying, well, here's the thing that I'm kind of stuck on. Is there something we can do to sort of have a foot in both camps here? Have your colleague or your adversary become part of coming up with the solution. If you begin with, I see it this way, and of course all correct-thinking people see it this way, and you poor benighted slob, don't see it that way, and if you'd only be smart enough to change your point of view, we'd get along great. It's probably not going to be a successful strategy. So you want to create opportunities to come together and enlist the other person as part of that problem solving. Occasionally you're just not going to be able to get there. It's important to say, I think we just see this differently, or we may just have to find ourselves on opposite sides of the fence on this one. But leave open the notion that on the next case, maybe we really can come together. When you find yourselves drawing lines in the sand and saying all the sheep are on this side of the line and all the goats are on that side of the line, pretty soon all you're going to have is sheep and goats. And that's not a very good way to build consensus.
Do you think that part of that is making sure the other person feels heard? So that, and that is probably making an investment in letting them get to a point where even if you reach a disagreement, there's a respect because you've given them that respect of really listening and hearing them.
Yeah, I think it's that. And I think it's conveying to them that you really are open to thinking about it. I may have come in with this view of this case, but you said something that I really hadn't focused on before. And you may be able to diffuse a situation by saying, I really want to go away and think about that a little bit more. Then at least you don't have to be extemporaneously brilliant. You can come back later, But it is a human enterprise. And if you treat it like a human enterprise instead of like a war, you are much more likely to find consensus when it's possible.
I agree with all of that, and I say that I am the beneficiary of having worked with Kay Werdiger and Carol Corrigan, some of the most diplomatic, humorous people, bright as whips, and when they disagree with you, it takes a while to think, did she just disagree with me? And that's an art, I'm gonna say, and because it's done in the kindest way, sometimes with humor, sometimes it's even a sound. I once heard Kay say, "Oh!" and it just slayed me around the table. And it was the right "oh" at the right time, and it was the right inflection. It made me think about the conversation. And I will tell you, Carol Corrigan is is the greatest mediator I've seen in action when we're sitting around a table. She tries to bring everyone's point of view together to get to where we are. And there's a lesson in that, I think, and there's a lesson, particularly I've seen it in law in motion in the trial courts, and even amongst colleagues trying to get together to prove a point, is you, as Carol said, you never back someone into a corner. You let them create room for them to gracefully change position. Create a way that they can come to your side without looking like a complete idiot. Oh, I see your point. And I will also say, in this exchange of information where you're treating each other how you want to be treated yourself, you truly, if you're listening, you're learning something, not only about the case or the rule or the difficulty, but you're also learning about how that person thinks. And you're learning that the next time when you have another case or another issue, you know how to prepare your argument. You know where they're going to disagree with you. I mean, I gave an example. I was on the Court of Appeal, and one of my colleagues never, ever, ever wanted any legislative intent. Never, never, never. Didn't believe in it. How can we resolve these things? He would fume at legislative intent. So when I crafted a draft memo for the Court of Appeal, I knew, oh, is he on this panel? No, don't put any in. Don't put any in. And make someone else say, you know, I think it's ambiguous. We need to go to legend. Never start off that way, because it's going to alienate him. So if someone else suggests it, well, now we're all in solution here. I don't know, Justice so-and-so wants some legend 10. I can't ignore that, Justice so-and-so. So you try to be very kind and humorous. I have heard honestly, the most subtle disagreement, and then it turns into, can you explain why? One of my favorite sayings, I think I heard you say it first, is, can you unpack that? Can you unpack that? I'm just not where you are. You're here, I'm not there yet. I have enough trust in you to ask and to tell you I don't understand it. Can you unpack it for me? Oh, and now I'm here with you, because now I understand how you arrived at that conclusion, and so let me go back and think about it.
Thank you.
And we seem to be losing our ability to do this. We just want to go to war, because we're so completely embracing of our own virtue and rectitude that, you know, we have lost often the ability in American dialogue to honestly disagree and then work hard to see where we come together. And I suggest to you that it is the responsibility of people in this room to help recapture our ability to speak with one another respectfully and honestly and openly with an open mind. I hadn't quite thought about it that way before. Acknowledging that the other person may have a kernel of truth is not a mortal sin. It can often be the beginning of a wonderful relationship. You know, you may really be able to come to middle ground. So I invite you as counselors and advocates to work hard to help us all here in American life recapture our ability to do that.
Thank you. So we're toward the end of our time, but I wanted to give you each an opportunity to give some parting advice. We have women lawyers who are on the entire road of a journey. So from first year lawyers, even maybe before first year lawyers, all the way through, who might be in their second or third acts as lawyers. What piece of advice would you like, now that you've been through your journey, or still on your journeys, that you would like to give to our members? And I'll start with you, Chief Justice.
Thank you. Well, I would say that, based on my own experience, practicing law and being in a court is because there is an unresolved question. There is a dispute. There is a problem. It's a very challenging kind of profession. There's conflict. There's a lot of ways to have disputes and many levels of the dispute, as we've talked about here. And so I think it's important that you know and remember every day that you should not be your own worst enemy. We all make mistakes. There are all things we regret. Some things escape our mouths. Sometimes we've been not as discreet as we should have been. There's a whole host of a panoramic picture of errors that we can make in our career. And I think the best thing you can do is try to rectify it. If it requires an apology or it requires a face-to-face, do it. Do it as soon as you can. Get it over with. Be sincere. Don't beat yourself up over it. Do all you can to ameliorate and to mitigate, but don't carry it around. Don't let it build upon you. Don't think you're alone. Don't think that you had to be perfect. You're not supposed to be perfect. If it were perfect, why would we have all of these reporters and books and statutes and CalGIS? It's not. It's not clear. It isn't. A human life never is. So I would say to you, just go easier on yourself in this profession.
Justice Werdegaard?
I certainly endorse what the chief said, and I hope you all take it to heart. I would say that we hear that some of you are in the beginning of your career, some of you are perhaps very experienced, don't need this advice, but I would say prepare to work for what you want. Chances are it's not going to come early and it's not going to come easily, but if you're dedicated to your work, have faith that you will arrive where you want to be, and cherish the experiences you have along the way. I now have a long view, looking back on my career, and I cherish the people that supported me, and I've tried to let go of the people who did not wish me well or who stood in my way. So prepare for a long journey, commitment, and be good to yourselves.
Justice Gordon?
If you are beginning, be sure to listen to the people who are urging you to look over the horizon. Not everybody who gives you advice will give you terrific advice. If someone comes up and says, you know, I think you ought to take up fire juggling, you can nod politely and think, you know, I'm thinking fire juggling is not good for me, but don't be afraid to really give some serious thought to something that you have always thought, people like me don't do that. That's at one
If I
end.
might interrupt you, I think each one of us sitting here had, it came out earlier, had to be, somebody had to push us to do and to end up where we are. None of us said, that's what I'm going to be when I grow up and it's going to happen. Somebody, so going, interrupting you and confirming it.
I'm always happy to be interrupted by you, Justice Warden. But
See?
on the other end of that spectrum, be the person who encourages somebody else. I was teaching at the Judges College a couple of years ago, and an African-American woman came up to me. She was a brand new judge, and she said, you probably won't remember me, but I was in one of your classes at Hastings. And I remember you said, now this is never good when someone comes up to me and says, I remember you said, because it's like, could be anything. So whenever somebody starts that way, I'm always a little in trepidation. But she said, you took me aside one day and you said, I had some talent and I might really want to think about being a judge someday. And here I am at the Judges College. And there will be times in your lives when you have, and you know, you don't have to be a full-time mentor. You don't have to have the I'm a mentor t-shirt in order to do this. Sometimes the simplest encouragement changes a life profoundly. Be that person for your colleagues. Be the person who says, gee, that was really a great argument. Or have you ever thought about doing this? Because I think you'd be terrific at it. You plant a seed that, you know, you just never, now sometimes those seeds just, you know, that are like fire juggling. But often they take root. And when they do, it's magical, both for the person who has the benefit of this wonderful new flower, but also for the person who planted it. So be that person.
So we're going to have Selma give you the last piece of parting advice today from our panel. So Selma, you have the last word. What is your parting advice to our members?
Really, you know, these youngsters have all been talking to you about things that you have encountered already, you will surely encounter. Bear in mind that when I passed bar, when I was actually being sworn in by the Supreme Court in Los Angeles, and just to know that in this country at that time, that was 76 years ago, that there were only 3% of the lawyers in the country who were women. 3%, if that gives you anything to start with. And I simply want you to know that there is a great deal more that lies ahead. And I've been thrilled to hear, and now you know why I said to our president, I want to bring our Supreme Court, which is why you see Selma and the Supremes. I didn't see that when I was looking that way, but there it is. And that's the truth, because if you all want to send a note of thanks to me for having brought the Supreme Court, I would consider it very good manners, you know, and a good way to remember that listen when the elders speak. They have lived a life you have gotten to yet. And maybe there's something more. What I have been hearing has been a sheer delight, because it is so true. And every one of you go out and do every one of those things that were given to you. But this is truly, I say to our president, now you see why I had in mind that this is what I wanted to do for this encounter, for this event. I wanted to have my friends.
Thank you, Selma.
From
And we want to thank you. And so we're going to have an early 100th birthday celebration for Selma. So can we all start with Happy birthday to you. Happy birthday to you. Happy birthday, dear Selma. Happy birthday to you.
That can go on when things are in the dark, you see. And so my thanks, I don't know, did all of you have something to do with the birthday cake? Yes, I know. But I wanted to give you the opportunity. That is something you can always remember to do in court. Get there first, and then you can get all the credit for it. So, what can I say? This has been a beautiful, beautiful event. Certainly unforgettable for me. You'll have longer to remember it.
Blow out the candles before you set us on fire.
I have to make a wish first.
Yes.
You know, when I had a 95th birthday celebration in Los Angeles, and I remember saying some words that come to me now, and that is, I am profoundly grateful for the gift of time, for the richness of the years, the privilege of the years. And I am going to make my wish, and that is, I wish the best and the same for all of you. For all of you, my sisters in law.
Thank you so much.
Thank you.
Thank you again to the justices, and one more big round of applause for a wonderful day. Thank you so much. And please join us now for some of the cake and cocktails out in the garden terrace. Looking forward to getting to know more of you later this evening. Thank you.